Passage 16. Start. The question of inter-se seniority of High Court judges has been raised off and on either on the administrative side in the respective high courts or through representations addressed to the President of Pakistan. Such issues, though important for the judges concerned, yet have a potential to cause some ripple in the committee of judges, and it is imperative that those be resolved in the light of some objective criterion to be laid down by this court, leaving the question of seniority to be decided by the President or by the concerned Chief Justice of a High Court without reference to any objective criterion may raise issues of judicial independence, is mandated under the Constitution and is essential in a democracy. Judicial independence, both of the individual judge and of the judiciary as an institution, is essential so that those who bring their causes, cases before the judges and the public in general have confidence that their cases would be decided justly and in accordance with law. Judicial independence is one of the foundational values of the Constitution of Islamic Republic of Pakistan, which is based on trichotomy of powers in which the functions of each organ of the state have been constitutionally delineated. The very preamble of the Constitution pledges wherein the independence of judiciary shall be fully secured. The Constitution makers conferred this independence because they wanted the judges to do right to all manner of people according to law without fear or favor, affection or ill will. Oath of office of judges, the fundamental rights guaranteed under the Constitution cannot be secured unless judiciary is independent, because the enforcement of these rights has been left to judiciary in terms of Articles 184, 3 and 199 of the Constitution and the relevant law. Judiciary has not been made part of the executive or the legislature. Article 7, the separation of judiciary from the executive was made a constitutional mandate. Article 175, so jealously this independence has been guarded that even in the appointment of judges, Article 175A, and in their removal, Article 209, the primacy is that of the judiciary. The Judicial Commission is headed by the Chief Justice of Pakistan, and its members comprise of four senior most judges of the Supreme Court, a former Chief Justice or Judge of the Supreme Court, Chief Justices, and senior most judges of the respective High Courts. If the appointment is that of the Judge of the High Court, Minister for Law and Attorney General for Pakistan, as also representative of the bar, the recommendations made by the Judicial Commission are sent to the Parliamentary Committee, which is to decide within 14 days, failing which the recommendations made by the Judicial Commission are deemed to have been affirmed. The primacy in the entire process of appointment of judges is still with the judiciary. The court, through this judgment, in laying down a criterion guideline to determine the inter-se seniority of the judges of the high courts, has partly been influenced to protect and preserve this seminal constitutional value. Full stop and close.